The defendants discussed in these clips have only been charged with these heinous crimes, not convicted of them, so they are innocent in the eyes of the law and the world, until proven guilty in a court of law. So they are potential garbage human beings.
Good morning, Your Honor.
Good morning.
Good morning, Ms. Caldwell.
Good morning. Thank you, Judge. So this is a defendant who is being held for warrants on exploitation of children and by an employee or agent in the first degree. This defendant has been in custody on these warrants since November 15th of this year, being held without bond. Bond was denied on November 16th of this year. Judge, the facts as we know them currently are that the defendant was an IT specialist at Drew Charter High School, and the victim in this case was a student. The defendant and the victim began communicating on Instagram, and the conversations turned and eventually included exchanging nude photographs. The defendant also sent the victim, who is 17 years of age, $200 for her birthday on CashApp. According to the victim, the only in-person sexual contact was when she met up with the defendant around her birthday, and the two engaged in oral sex at a skate park near the Beltline. On November 10th of this year, a friend of the victim informed a school social worker that there were, quote, pedophiles in the building. When the social worker inquired further, the friend provided the victim's name. The victim, who also has autism, admitted that she was receiving text messages from the accused, who is employed at the school, asking for explicit material, and that the victim provided such to the accused. The mother of the victim also indicated that her daughter had been receiving explicit sexual content from this defendant. The victim was forensically interviewed earlier this week, Judge, and the information that was learned from this forensic interview was that there are 3 other victims involved in similar circumstances as her.
This defendant has 2 charges. One is the exploitation charge, and the second one is contact by an employee or agent in the first degree, which is Georgia Statute 16-6-5.1. This statute is actually unique to Georgia, and it has to do when the defendant was in a position of authority over the victim, say a teacher at a school or a psychiatrist, an employee at a prison, or a medical professional, where the victim should have been able to trust the defendant. And there's that extra layer there that makes it a little bit worse. And the punishment for this crime is actually a little bit harsher than the others.
The victim disclosed that the defendant worked at the Genius Bar, which is where the students would receive technical support at the school. The defendant befriended this victim through social media, though he has known her since middle school. The victim used to date a boy who also worked in the Genius Bar. Their relationship, according to the victim, started getting weird around late March of this year, when she walked past the defendant's car during her lunch period. The defendant offered to give her a ride for her to charge her phone. The victim said that upon their return to school, other kids saw her get out of the defendant's car. In April, the defendant started texting the victim. He told her that he gets high. The defendant also texted the victim that he wanted to, quote, smash. He told the victim that he and his wife sleep in separate rooms. The defendant texted this victim nude photos of himself, and she sent nude photos of herself back to him. The defendant tried to convince the victim to leave school and go and have sex with him. The victim disclosed 3 other girls are also victims of this defendant, and did give some additional details about those victims and the situation. I won't go too much into depth into those right now, Judge, but what I can say is that some of the incidents involving those other victims took place in Fulton County. So it is highly likely that Fulton County will also have charges against this defendant at some point. The victim, during her forensic interview, did disclose that the defendant told the other girls to lie to his wife and say that they were 18. This victim said that she did know that the defendant's wife had seen text messages that the defendant had exchanged with her and these other girls that are also victims. The victim further disclosed that the defendant would allow her to vape in his office at the school with his THC vape pen. The victim suspects that the defendant's wife reported their relationship to the school as the victim was asked about a suspicious CashApp transaction, which I mentioned earlier was the defendant's $200 birthday gift to this victim shortly after the defendant's wife separated from him. As far as a criminal history for this defendant, Judge, it goes back to 2008. There is a criminal trespass out of Riverdale Police Department. There is no conviction or disposition, so I don't know what the disposition is. And then in 2010, the defendant was arrested for a shoplifting in Riverdale, and he completed a pretrial diversion program, so that charge was likely dismissed. As far as a victim stance on this case, Judge, we do have the victim's mother on the call this morning, and she has indicated that she would like to address the court regarding bond whenever the court is prepared to hear from her.
Sure, I can hear from her now, and then I'll hear from the defense.
Yes, ma'am.
Hello, Your Honor.
And Ms. If you could turn on your video for us this morning. Okay, thank you very much.
Hello.
If you could just let Judge Piegler know your thoughts and your position on this defendant receiving a bond today.
I have a lot of thoughts, but I'll try to condense it. My daughter has autism and anxiety disorder and OCD. Our whole family, we just have not been sleeping. We have not been up. Our appetite has been wonky. I had to shut down my business. I own a salon, and I shut down my business during the holidays to deal with this, dealing with detectives, therapists, and all those things. My daughter's afraid. She cannot sleep. She doesn't feel safe. She's afraid that he's going to leak photos, cover evidence, and even kill himself and not give her the justice that she deserves. My daughter wants to say something as well, if that's possible, Your Honor.
Well, let me say this. Certainly, I will hear from anyone who the state wishes for me to hear from, but I will note that this is a public hearing.
Okay.
And it is being live streamed. And as far as any privacy and that sort of thing, you and your family lose that the more you speak in this forum today.
I understand, Your Honor.
Yes, Ms. Jackson-Reed, unless your daughter has anything significantly different to add this morning as far as her thoughts on bond, I think that what you have provided to the court may be sufficient for the court's consideration and for the state to argue on your behalf this morning.
Okay.
Okay.
She still said she wanted to make a statement, if that's okay.
Is this what the state wishes? Hold on. Ms. Caldwell, is this what the state wishes?
No.
It would be the state's preference to not have the victim appear on camera this morning and make a
Okay.
statement unless they feel very adamantly that they would like to do that. But it would be the state's preference to.
We'll respect the state's preference.
Okay.
Um,
You went on mute, Ms. Caldwell.
Sorry about that. Thank you. Yes, Judge. So the state is in agreement with the victim's position on bond. We are very much opposed to bond for this defendant this morning. We do believe that despite his lack of criminal history, he does pose a danger to certainly persons in the community. We have evidence of at least one victim here that is a minor that he is improperly involved with. And we do have information that there are likely 3 more victims. So we are very early in the process right now, and we would ask that for the time being, bond be denied.
Okay, let me hear from the defense.
Good morning, Your Honor. I'm here this morning on behalf of Mr. Elliot Hinton. He is 32 years of age. And let me first say that, I know that DeKalb County runs their processes differently. So Mr. Hinton actually does have a dozen or more family members and friends who are on YouTube watching, who were here to support him, but we're not allowed to log on this morning. So insofar as familial and community support, he has a dearth of that, Your Honor. And they've been very communicative with my office, and everyone is here supporting him. They're just on the live stream on YouTube. His current address is in Ellenwood, Georgia. If the court wants it, I have it here in front of me. He has been in that same rental home for the last 40 years, and his name is on the lease. And if bonded, he would return to that address in Ellenwood, Georgia. He was born and raised here in Riverdale, Your Honor. As the state said, he has no relevant criminal history. The shoplifting was when he was 17 years of age, and that case was expunged in Riverdale and Clayton County. Your Honor, he is educated. He's been to school at the ITT Technical College, where he did a year in information technology. He has attended the Art Institute of Atlanta for 2 years with a major in graphic design. He did graduate from high school in Riverdale. Your Honor, he has been fired from his job at the school, but he is actually still married and is maintaining his marriage. His wife has been very communicative with my office and is still supportive. Her name is Nanlyn Hinton, and they have been together for 12 years. He has other family members here in Georgia. Frida Hinton, his mother, lives in Stockbridge. And Julian Hinton, his brother, also lives in Stockbridge. He does have one daughter, Amy Hinton, who lives with he and his wife at the Ellenwood address, Judge. The state is obviously, bringing up some new information for us this morning. They have the benefit of arguing with all of the case information that we have not yet obtained, Judge. So I don't really know what to say about what was obtained in a forensic interview this week, or the reliability of those facts. But for Ayala today, what we're looking at.
We've heard Ayala factor discussed before in Fulton County courts, etc., but we've never really gone over it in detail. And what it is a case from 1993, Ayala v. State, and it's become the most important case governing bond in Georgia. And in their decision, the court said that the purpose of bond is to prevent punishment before conviction and to secure the appearance of the person in court. They also outlined several factors that should be considered when deciding bond, and that is the defendant's length and character of residence in the community, employment status and history, past history of responding to legal process, and prior criminal record. And all of those things need to be taken into account when determining whether a defendant should be released on bond or held in custody until their hearing.
Is Mr. Hinton, and will he return to court? We have no reason to believe that he won't. When involved with the law before in Riverdale, he successfully completed the terms of his pretrial diversion, and that case was expunged off of his record. He went to court. He did what he was supposed to do. There was no fleeing from any jurisdiction, nor has there been any allegation from the state that he would not appear for court. Likewise, Judge, his familial ties and community support here, a lifelong resident of Georgia. He has no desire to go anywhere else and wouldn't if released on bond. Your Honor, we would understand if the court had certain conditions of bond that you would like to entertain, such as, a ban from contact with minors. I would ask, if you do that, Judge, to allow him to continue to have contact with his minor daughter, who is 10 years of age, Amy. There is no allegation that he has in any way acted inappropriately with his daughter. We would ask that he be allowed to move back to Ellenwood and reside with his wife and daughter there. All that being said, Judge, we believe he is a good candidate for bond. Regardless of what the state says, I'm not trying to downgrade any of the things that the alleged victim feels, etc. But Judge, we have a case where this man has no criminal history, and according to the IALA factors, is a good candidate for bond. He's got familial support. He's been gainfully employed. He's been well educated. He has a home here in Ellenwood and would like to return home to his family and work with us in our office towards clearing up these matters. And so far as Fulton County, this is the first time I'm hearing anything about that. And obviously we would be dealing with Fulton County in those matters should they ever be brought by the state, Judge. At this point in time, those are new allegations or accusations coming in from this week, and I have no information on that. All that being said, we would ask for a reasonable bond, Your Honor. He has been in custody for a month on these charges. We would ask that he be allowed to leave and stay at his Riverwood address. Likewise, Judge, I believe that allowing him to be out and work with my office would also allow us to do the testing that we would need to have run, that we do as a course of business at the office, that is not able to be done while he's in custody. So I think it is important for the justice in this case. I think it's important for the defendant to be able to properly defend his matter, Judge.
Okay, thank you. Based on the information that has been provided to the court, I am going to deny bond on the grounds that he poses a significant risk to persons in the community and a significant risk that he will intimidate witnesses. Bond denied.